Smo and O clip that day? I don't know. Why did they blame Yellow Beezy? I don't know. Truth is, Boosie had a lot to gain by watching Mo 3 move around. Maybe that's why they shot him over there at the Big T after the wake. A lot of shit goes down at the Big T, but for Boosie to get shot, I guess that's why Mo 3 got shot right over there. I guess that's why I couldn't stay in Dallas. I had to get out to watch Mo 3 be assassinated, executed, running for his life down this highway in the middle of the day. Like, it was this time of the day. Look how busy this is. And somehow, he was forced to stop his car. Someone stopped their car as well, got out the car. He saw them, he must have recognized, because he turned and started running down the highway in the middle of the day. And they shot him in the back. Does this make any more sense than the Tupac shit? How the hell was there enough time on a busy highway like this at this time of the day? Who does a shooting in the middle of a highway? She in the middle of the day. And still no answer. It's always too hard to solve a rap murder. Another graveyard.
Set it off, Jag.
Welcome, welcome, welcome. Greetings. You know, yesterday was a very eventful day on the channel. So I just want to make it very clear. It's members only content. I was on one. And rightfully so. But, you know, I'm not past creating a little bit of outrage. You know, just to, you know, for a little bit of engagement. Today though, we're leaving everything open. Please subscribe. Please come in, because this is a really, really, really important moment right now in time. Tory Lanez is back in court. How are you feeling about it, Wolfgang?
Peace. Yeah, this is interesting. I'm just like, I mean, what is there to say? Because truth be told, it looks like there's a lot of blocking. There's a lot of things going on with this situation, and that's why I just want to let's chime in and see what's going on. I mean, so the appellate court is now speaking. I think there's other cases going on. I'm not going to chime in there.
Mm-hmm.
But I think as soon as we hear his case when it comes up,
we might just share it.
We'll just share it. We'll just go in. I'm trying to figure that part out as well, because you know it's actually like it's a certain type of stream that they got. So I may have to put it on another like share it a different way. That's all. But yeah, we're live. I'm gonna try to just streams right from the court. They're conducting the oral arguments right now.
Okay.
He is scheduled to be in this morning session, which it started a few minutes ago. I believe he's number 23. And yeah, they have a few other cases to see. So
well, let's shout out a few people who got here early. Hey, what's going on? Welcome. Listen to me. It's not members only today. Because we want to make sure that everybody can get involved. We want to hear what people have to say. Welcome in, Hope. We got Martha. Hey, what's going on, Martha? Martha C's in the building. Hey, M, welcome. Welcome. We got Cat Eyes coming in from Memphis. Lorenz, hello. Welcome. Welcome. Who else do we got in here? Oh, we got Yvonne. Welcome, welcome. Well, listen to me, one way or the other. Like I said, we're here. We're monitoring. We're going to be going over the blow by blows. We're going to be doing a bunch of stuff today. Pat Blair is in the building. Hey, Pat. Cherie. Who else do we have here? Everything is okay. And you know what? Everything always is. Hey. You're trying to like the video and it won't let you? They be hating, man. They be hating. But we appreciate you being here. So I'm not sure if we're going to
I'll play it when it goes. No, we got it popping. And I'm gonna play it as soon as so I just gotta keep.
I think people were under the impression that we're not allowed to do that. No, that we're not allowed to do this, that we're not allowed to stream or share this. So
who said that?
I don't know. It doesn't really matter. Hey, Jennifer Sofranco, welcome. One of our new members. So should we turn on a little music?
Yeah, go ahead.
It feels a little dry. Hold on a second. It's been so long. Like, they've changed everything so much. Where are our instrumentals? Oh. Hold on a second before we get going. You want to choose what we're playing today?
Yeah, no, go ahead. I'm actually looking up something else. I'm actually trying to find out about the restrictions. Give me 1 second.
Okay.
Because
there we go.
There we go. It says generally electronic recording, video, still photography, or audio capture of live stream is prohibited without prior written permission from the court. So if it's ultimately up to the judge's decision. Let me look and see. That's all. I just need to see if it's fine to live stream. But we should be good to go. Regardless to what, I'm listening, and that's what it is. I could just translate, or I could just tell everyone what's going on. But yeah, y'all. What boy? Okay. Do I want to address this boy backs? Because in all honesty, I want to say something. Maybe I should say something. What do you think?
I mean,
I kind of want.
You got every right. You got every right to say whatever you want to say.
And you don't have to say anything, Jag. Let me just go ahead and hold on, because I'm trying to
actually I got a better idea. No, it's fine. I got a better idea. That's that anybody who's not talking about what's going on here, you getting thrown up out of here. It's just that simple. How about that?
There we go.
I took care of that.
Let's just do it like
right
that.
Now,
but I'll get with you about the situation with Brian McKnight. Let me just say it like this.
What?
The guy, number one, doesn't have a case. I'll just say it like that. He hasn't served you. He said he's been trying to look for you. There's a whole lot of things that he's doing or whatever. But what's going to happen is we're gonna have you answer to it regardless, because guess what? There's a claim for the truth defense. If you believe the statements were factually accurate, Jag, they can't deny it. So why? See, all this is all theatrics. He know he's screwed. So I'm gonna say it like this for this Brian McKnight situation. The claim that Jag has is a truth defense, because you know the statements are factually accurate, and it's gonna get dismissed anyway, regardless. So y'all run tell that.
Well, the thing is I'm still trying to figure out how everybody's making a big deal about something that we haven't even actually seen ourselves.
Oh, I did the research. Research, and I'll that's why I said we'll talk about it later. But
yeah, well, it's not even. I'm not even worried about it.
No, that's what I'm saying. Your claim, you have a truth defense, and you were not making statements with actual malice. He doesn't have a case. Your First Amendment protects you. Your First Amendment protects you. So he can't even move forward with the case because it's not going to get served. He wants to do something with the newspaper, blah. He doesn't have a case. I'll just say it like that. It's not going down.
You know what I don't understand? Why everybody's so interested in all of these salacious weirdo stuff, but nobody wants to focus on what's real. And
they
what's
don't
real,
want to talk about situations like Demore and what's going on with Tory Lanez.
Exactly. Not at all. Not at all.
Brian McKnight.
Listen to me. The funny thing about it is I don't even really talk about that man. Not for real. No, unless somebody brings it up, or unless somebody asks me a direct question or whatever the case may be. No, there's nothing for me to talk about. He's not worth talking about. And that's what's funny. Because what a lot of people have realized is that putting themselves in a negative situation with me, in negative engagement with me, helps them. It helps them. This is helping him. Period. And salute to Dr. Lily, Ramir's godmother, and salute to Ramir. Like, there's just so many injustices that are happening in the world. And you have to ask yourself, when people start going out of their way, like, the question is he going to go after everybody else who has something else to say? Oh, here we go. I'm not even putting that up on the screen. What we are going to do is block and ban. I find it funny that these people
they're probably from my what's the name? I got mine. Let me go ahead and well, you already know what I'm doing with those two, because people that are coming in with that type of stuff, they're gonna I just gotta holler at the legal situation. So that's great. Let them keep doing it. But yeah, definitely block and ban.
All right, guys. You know, it's so funny. People keep getting memberships. People keep subscribing, and for whatever reason,
to harass.
No, but not just that. YouTube keeps blocking their subscriptions, blocking their membership.
On your side,
yeah.
And I was talking about me. They're sitting over here just to harass. They're weird. Auntie Leah, you probably gotta be on my channel, because that's probably where they're at. But I think Jag is members only. And
no, I'm not.
Oh, you're not.
I didn't set it for members only.
Oh, you did subscribe. Okay, so I set it for subscribers only. Okay, all right.
Yeah,
so that's
I didn't set the rooms today.
Okay. Well, we got it. Auntie Lee, appreciate you.
It's really sad. It's really sad how many people just like clout chasing for engagement.
Yeah, man. And then you got people on here that are just like, weird and nosy.
Oh, absolutely.
Just weird and nosy.
Absolutely. But you know what? I've come to learn that about YouTube. Like, it's really weird how this particular construct, this particular app, um, it's just wild, man. It's wild because, like, there's a whole culture here where being negative is what you want to do.
Mm-hmm.
Like, 2/3 of the content creators are here to make negative content and for negative engagement.
Yeah. Yeah.
And also that they can be seen on the screen. And yeah, there's a real sick American obsession with attention.
Yeah. Mariana
Hello,
Calhoun.
Mariana.
Mariana Calhoun. Appreciate you.
Welcome, welcome. And guys, just so you know, we're broadcasting from 3 channels today. So we're over on the Jaguar Right Effect, we're at Set in the West, and we're also at the Jaguar Right Show. So if we could have the mods like fan out between or just spread out between, you know, all the channels, that would be really great. Welcome. Welcome.
Okay.
So I think right now what the plan is going to be is Wolfgang's going to be listening while we're checking to make sure that we're not breaking any rules.
Yeah. I mean, I can always just relay what I'm hearing. So they're talking about something else right now. They're not even talking about the situation with Tory Lanez just yet. But for those who don't know, and the reason why I want to speak on this is because the Tory Lanez appellate proceedings today is, well, we're here, we're listening, but his habeas petition was denied. So the appellate court recently rejected 2 of Tory Lanez's habeas corpus petitions.
Mm-hmm.
Do you guys know what habeas corpus means? I don't know.
Well, why don't you explain it to them? Now, I've been released on habeas corpus before, so I understand what it is, but you tell them.
Well, I think habeas corpus is Latin. That's what I know for a fact. That habeas court. What do they call it? I'm sorry. I'm
habeas corpus.
Habeas corpus. Habeas basically means bring the body, right? It's Latin. Like corpus is body, and it's basically your legal right that protects people in the United States for unlawful imprisonment. It will allow Tory Lanez to challenge the detention, his imprisonment, to the judge.
Exactly.
And, it's a cornerstone to due process, safeguards against arbitrary detention. I understand he's Canadian too, but his petition now is sought either an evidentiary hearing or a new sentencing citing new evidence. Hold on, I'm trying to listen to it at the same time. His legal team claimed that the new evidence was unavailable during the 2022 trial. And it's basically the statement of his driver, Mr. Smith, and a security guard for Kelsey Harris. So court ruled that these efforts were either inadmissible, forfeited, or untimely, effectively shutting down those lines of defense. So specifically, the court noted that Tory Lanez and his counsel chose not to call Smith as a witness during the trial. And then the security guard's affidavit was deemed untimely, as it was submitted long after the trial concluded, which was kind of, orchestrated. They did that purposely.
Well, I mean, that seems to be but that seems to be a lot of what's going on. If we look at what happened during the Diddy trial, there was so much evidence that was not used against him, that should have been used against him.
Yeah.
But it had been destroyed. It had been corrupted. This seems to really be it's just it's a nasty it's nasty. It's
Yeah.
just nasty. I'm tired of it. Even with Demori's situation, them trying to fight putting in the body cam footage. The body cam footage is real evidence, actual evidence. But they don't want that included because they don't want the judge or the public seeing what's really, you know, going on. It's so frustrating because, all of this stuff that these people are doing, it's almost as if it's gotten to the point now where if you know how to cheat the law doesn't matter.
Mm-hmm.
Like there's way too many technicalities. Like for instance, Marilyn Manson. A lot of people don't even realize Marilyn Manson was just on trial for some really, 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 really nasty, nasty stuff. I mean, nasty stuff. Unlawful, detainment, pretty much, keeping people against their will, sexual crimes, all kinds of stuff. And he recently just won in court. And guess why he won his case? Limitation. Statute of limitation had passed. He was able to keep it out of court long enough for the statute of limitation on the crimes that had happened against those women, that he had committed against those women, and he was able to get away with it. And boom, trial gone, and now he gets to run around pretending like he was innocent. It's bad. It's really bad. I mean, but the truth is the reason why a lot of people end up in jail unlawfully, end up being detained unlawfully, is for nothing more than the fact that they don't know the law. And when you look at all of the things that they're teaching in school, you know what I really think they ought to be teaching in school? The law. I think starting in junior high, there should be a mandatory course where all children learn the law. What it means, how it applies. Like, if ever there needed to be mandatory prerequisite for how to be a citizen and how to survive as a citizen in this country, that should be it. Because usually by the time most of these people commit these, so-called crimes or what's considered a crime or being charged with crimes, it's when people are young. And what do you think? I don't know.
Yeah. I just think I don't know. I just number one, Jack. I'm doing like duo listening, so I'm listening to what's going on. So
Oh, I know. I'm sorry.
no, it's okay. It's okay because they started at one. So I basically, I just say justice needs to be uh, uh, put. Justice needs to be produced. Let's just say it like that. Justice needs to be produced. I'm sorry.
I find it funny.
What do you find funny?
Yes, Marilyn Manson is still alive. No, that we give directions, and no matter what directions we give, people keep breaking the rules. If you are not talking about this case, if you are not talking about what's going on, you will be
Oh,
blocked.
you'll be
You will
blocked,
be thrown
man.
out of
That's
here.
pretty much it. That's all. That's all. So with Marilyn Manson, Manson's situation, I don't think it wasn't highlighted, right? Like
No,
yeah, it wasn't highlighted, and that's done purposely.
that's the thing. The court system is dirty. It's supposed to be there for the people, but the truth is it's really just something that's used against the people, to corral the people, to control the people, to manipulate the people. That's what our court system has turned into. Like, if someone is doing something wrong to you, like for instance, there's someone that we know right now in our life that filed for a restraining order against an a DV partner who they are separated from, running, hiding from being served. You can call the police when they show up. You can call the police when they call. And guess what? They say, oh, well, there's nothing we can do about it. There's nothing we can do about it. Meanwhile, you got officers, like, for instance, what happened with Demore, when they were asked to come in and corral her, for the Baker Act, for the Marchman Act, for all of that was going on. Those officers didn't have to move forward with it. Matter of fact, when they were at the farm and Javon was arrested at the farm on New Year's, and they were there with the family, and it was very clear that she had not been abducted. It was very clear that there was nothing going on. Those officers could have walked away. They didn't have to. Apparently, they were expected to carry out those orders, and they get to say, oh, well, we're here now, so yeah, we're just going to go on ahead and take them because we got that call.
Mm-hmm.
It's wild, but it's true. You have so many cases that should be getting public recognition, that should be being heard by the public, because the truth is these people, the only thing they're worried about is their job, their control, and their access. And the reason why a lot of, corrupt officials in city government, in state government, in federal government, excuse me for crying out loud, are able to make it is because people don't know who they are. People don't know what's going on.
Yeah.
When it gets to the point that the public finds out who these people are and they realize that, hey, I might not get reelected, I'm not going to get this, it forces them to do their job. But once again, most people don't really understand how the law works. Why isn't the law taught in school? Why do you have to wait until after you've made it through all of your formative years to go to law school to learn the law? It's wild. We have thousands upon thousands upon thousands upon thousands of laws, and you know what? Most of them are ineffective. You have one law for one thing, you have another law for another thing, and guess what? This one cancels out, this one cancels out, this one cancels out, this one. Honestly, the way I'm seeing how a lot of things are working is most of these laws that we have out here these days, they're built with loopholes to be able to get around them.
Mm-hmm.
So the question is, who's agreeing to put these weirdo loophole laws into practice or into the art of law? Like, because you have to have a law made. Like, you can't just say, okay, this is a law and this is a law. It has to go through this form of government to be approved and then to be enacted. And it's not just that with constitutions and amendments, it's that with the law as well. Yeah, we know, lady, nobody on YouTube is talking about this. That's why we're here. And I'm not sure exactly how many people we have between all of the rooms. It's saying that we only have about 260
261, yeah.
and 261. So
maybe I need to change something in the no, it's okay. It's okay. It's okay. So Terrell asks, are we waiting for the hearing to start? The hearing has started, but what I'm doing is I'm being lawful, and I am not going to stream the appellate court's live stream, but I'm listening live, and I will give everyone an update. His case hasn't even been called up yet, but essentially we're here. We're going to speak on it. Let me give you a little context as well, Jag, too, real quick.
Yes, please.
So what's going on with the arguments for today that are being heard? For Tory Lanez, the main direct appeal, the component challenging the trial processes themselves, procedures themselves, rather, than like introducing a new evidence. So his appeal argues that the trial judge improperly allowed emotionally charged testimony from Meg the Stallion under unfair scrutiny of his music during cross-examination, among other claims. So the arguments are currently under review, and that's what we're waiting for. We're waiting to see, what decision will be made about that. So this is a setback. This could be a setback for Tory Lanez because the dismissal of the habeas petition, which we talked about earlier, that limits his ability to introduce new evidence.
Yep.
Or secure resentencing. You said those avenues are those are closed, at least for now, right? So the only remaining path forward is through a direct appeal. So Tory Lanez legal team, they gotta prove that significant trial errors occurred, whether procedural mishaps or evidentiary mishandlings. So the appellate court today, they're going to determine whether Tory Lanez's conviction could be overturned, or it will be remained or remanded for a retrial, or upheld as it is. So there's 3 outcomes that will happen.
It's sad that we have to go through all of this just so somebody can get a decent fair shot.
Mm-hmm.
Like, it's really wild. It's easy to end up in court, in jail, in a lawsuit. It's easy. Anybody can just throw your name in it.
Yeah.
But it's twice as hard to get out. And it's funny because it seems like there should be just as much it should be just as hard to create a case as it is to get one dismissed.
Oh no. They make it hard for those who really got, there's an injustice against. They make it hard. They make it so hard. I think it's people who know how to game the system, or money. When you're dealing with Rock Nation, allegedly, let me just say the alleged side. I'm hearing that they have judges on payroll, allegedly. They're in there. They got the hookup, so they can make things happen. And I think that's ultimately what it is. It's like, do you got the hookup, or and I don't think that's right. So I'm gonna say alleged with the whole, but if you look at everything, that's what it's looking like to me.
I don't know how this person keeps I guess they just keep making new screen names. So
Weirdos. It just came up.
I got rid of it.
Yeah, and see, certain entities don't want to take in consideration that people are being stalked on their platforms, and they don't. It seems like they don't take it serious. But some things are going to change. Like I said, I got a good friend who just made it to become a judge in Ohio, and he's got much love and respect for me, and he's got much love and respect for Jaguar. He's very aware of what's been going on with certain screen names coming in and harassing and saying certain stuff, and those people are going to be held. Justice will be produced for that. Just keep it up. That's all I really got to say. I really would just say keep doing what you're doing, because you're making our case better.
Yeah, guys. I mean, that's why we're here. We're here to make sure that people hear what's going on. Because I'm telling you, if you don't have people like us out here letting people know what's going on, the truth is how many people, I got a better idea. Let's take a little poll, shall we?
Sure.
How many people knew that this hearing was happening today? How many people knew? I want to know. Put a 1 if you knew this hearing was happening today. Put a 2 if you didn't know this hearing was happening today. How about that?
Not a lot of people knew. They knew about Donna T's meeting, hearing today. They didn't know about this one though.
You want to know what's funny? Why does anyone care about that?
Exactly. Well, I know why, because they're probably shaking in their boots, but that's a whole nother story. The thing is no one even knew he had a case for the longest. And it's funny, they go around YouTube, they pride themselves in outing or exposing people who have
Exactly.
cases, this and that. This thing's been going on since what you said? It was 2023.
2023.
The irony of that year keeps coming up. 2023.
I know. This has been going on since 2023, and he did a lot of stalking and a lot of harassing me in 2023. In 2023, so he was sitting here with charges, and none of these weirdos who are, oh yeah, and I went in the system, and I went in the system. A lot of people didn't know. I'm starting to see, huh?
Yeah, that's BS.
I guess part of the reason why that happens like that here on YouTube is so they can wait for the outcome. So whatever the outcome may be, they can take the story and spin the story and make it content, and then they can go back and forth and confuse people. So here we are today, and we're going to relay all of the actual real evidence. As you guys see, we're here. We're in the courtroom. And we're going to make sure everybody gets the truth today. Man, I tell you. But my question to you is because I didn't really get a chance to ask you, and we haven't spoken about it.
Yeah.
What did you think about the information that I found out about Candace Owens?
Well, I already told you she's not trustworthy. And her connection to these well, she basically you're saying that there's a connection to these white inferiorists, right? The Milo person, because that's one of like he's one of those, he's down with them, right? Like as far as what you're saying in regards to her connections and then her possibly being sued, and she's saying she doesn't have a whole bunch of money.
Well, it's like, it's not that she's possibly being sued. She's literally being sued by the president of France.
Well, see, I thought that a foreign dignitary couldn't sue an American citizen, but no, I mean, obviously, I thought incorrectly. I didn't know better. So I always thought, oh, okay, yeah, this is all. It's almost like with the Goofy McKnight situation. This is just all for show. That's what I thought. But they're taking it serious. Okay.
See, this is my thing. She went really far with this thing. I think the whole Kamala situation, I think that really, really, really emboldened her, because she didn't get a lot of pushback. She didn't get a lot of pushback for any of what she did in that situation. And don't get me wrong, did we need to know the truth about her background and who she was and what was going on with her? Absolutely. I'm grateful to know some of the information, especially when she sat down with Judge Joe Brown, and Judge Joe Brown made it very clear that there was relations between her and Jussie Smollett. A lot of people didn't know that. A lot of people did not know that. And when you think about everything that he was involved in, and when you think about all of the stuff that happened, like, man, how didn't we know? Why are all of these very, very, very close ties like constantly being kept secret?
Yeah.
And the only reason to keep them secret is because they know they're nefarious.
Yeah.
They know
Yep.
there's something rotten in Denmark with a lot of this stuff that's going on. And man, you apologize for not listen to me, Mariana. It's fine. This community over here, we're committed to making sure that the truth gets out there. We're committed, and we ask all of our members to make sure you spread and share because there are so many people that are just not getting the truth. Yes, he is in court today. Right now, there are other motions that are being heard
You said
regarding
two
other
more.
defendants.
I think there's two more right now, and I think we got maybe one more after this one, and then we should be hearing about his.
Oh yeah, you didn't know about that with the Donatella? Yeah, yeah. For years he was walking around, and it's so funny because they have their Crime Stoppers, they have their this, they have their that, and yet nobody knew anything that he was walking around here with a whole battery case on him. Like it's oh, you missed. Okay, so I bumped into another content creator, and shout out to Reese Waters and his Troubled Waters podcast and commentary. And I've been keeping an eye on what's going on with Candace Owens, especially after we bumped into that information about her husband, George Farmer, actually being, the owner of Parlor, because I was looking at the aspect of, what happened to all of your great support for Kanye. It was, you were supporting Kanye, White Lives Matter. You were going through all of this stuff, and then boom, the next thing you know, he's being heralded as an anti Semite, and you're just leaving him high and dry. You have nothing to say. Nothing to say. And I'm like, wow, you were just sitting there clout chasing Kanye. But as we started peeling back the layers to that onion, we started finding that there were more things going on with Candace Owens and her husband and her marriage and
Oh
her
yeah.
ties to
You know
government.
what? You know what? All that stuff that you were saying, I didn't say it went out right out the window with me because people have marriages and uh that's their business as long as they're not involving old people and children. I'm good, but that's nasty. But it makes sense. Like I honestly, it makes sense. I'll just say it like that. I totally forgot you mentioned that because I kind of said whatever. But yeah, I'm kind of laughing low key as well.
Well, this is my thing. When you look at all of this new information, it really starts making things a little bit more aware and a little bit more apparent. But now that I'm thinking about her interview on the Breakfast Club, oh, that was a total hit piece. Her interview on the Breakfast Club was a total hit piece. When you
Mm-hmm.
go back, you look at everything that's coming up about her now, and you think about the questions that they were asking her, because they asked her about her marriage. They asked her about how was her sex life with her husband specifically.
Mm, mm,
Specifically, they asked
mm.
her about what her knowledge was of black culture. They did a little black culture. You know, they hit her with the God is good. You know, and she said, "Yes, amen." Because black churches, everyone that's black American, your
People
FBA
say all the time, how you how
all the
you
time,
how you black and not know when someone say God is good, you don't respond back with all the time.
all the time.
You ain't black. Like Joe Biden said, you ain't black.
That part, which is funny because neither was his vice president. But
Mm, mm.
but it's just like super duper 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 interesting because technically, now that we're talking about these diaspora wars and we're talking about tether culture and all of that, wouldn't Kamala Harris technically be a tether?
Yeah, yeah, yeah.
Like they need to start saying stuff like black adjacent,
Black scented.
black scented.
Well, see, I don't even go with the whole FBA because at first it was ADOS, Americans and descendants of slaves, and then they talking now it's an FBA thing. I get it, taking power because we're in a position of power as Black people in this country, original Black people in this country, and yeah, we shouldn't call ourselves Black. Black is um, it's a designation. It's not like a race or a nationality. It's so truth be told, I'll call myself a freedman of, because my lineage goes back to freedmen. I look back and I was like, oh, my great 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 grandfather was a blacksmith. He was not enslaved, but I do have people on the side of the family that were, but we were majority freedmen, and freedmen is a designated class in the Constitution, but that's a whole nother conversation. But the FBA situation, or just basically talking about these others who try to act like us in this country, whether you call it FBA, Foundational Black Americans, or freedmen, yeah, they are effing up the game. I'll just say it like that because everyone else kind of, when I talk about everyone else, I'm talking about every other ethnicity, every culture, every race that comes to America or out or whatever, they can, they can say, oh no, that ain't us. Those ain't our people. You know what I'm saying? But anything that's dealing with criminality, anything that's dealing with effery, and they just say black. They go, well, that's not that person could be black, but that person could be Haitian. That person could be, you know what I'm saying? So it's like, I get it. I definitely understand it. But we got a whole bunch of people that are going around just making it look bad for regular Black folks. Because that's really what it boils down to. Most of us ain't doing all this effery and not a lot of sisters. Candace is a bad example. Not a lot of sisters is going to do a whole lot of heavy lifting to put the rest of their group down. So she's making Black women look bad. I'll just say it like that. You know what I'm saying?
Well, understand this. If that's her job, that's her job.
Right.
And to answer you, ACG, yeah, most of them are phonies. Most of them are full of crap. That's why they'll never put someone like me in a high media position or fight against me in a high media position, because they already know I'm not going to spread their schwill. I'm going to tell the truth. Our Zoom conversations that we had with Dr. Short. Yeah.
Jag is coming up. All right. So
okay,
the current item is up. The People versus Daystar Peterson. I'm just going to go verbatim on what's being said.
Okay. All right, guys. Let's take a good listen.
Okay, so they're just addressing. Oh man, they asked for 30 minutes of oral arguments. So someone from Moral Legal Service. Let me see if I can. Should I do the audio? Maybe I could just do the audio.
I don't know.
I think we can though.
I don't know.
Okay.
I'll let you decide. I just don't want anybody coming after these channels again. We've been through enough this year.
I think, okay. Give me 1 second.
All right, Ms. Zach.
What I'm going to do is this. Give me 1 second. They're talking about the errors with this case. They're talking about Kelsey Harrison's statement. So I got an idea. I think I can do this. I'm looking it up. So I can do this. I'm going to just run the audio. That's what we're going to do.
Okay, yeah, so we're allowed to run audio?
We're going to we can run the audio. I was just waiting to hear back if the legalities of everything. So
okay,
we can run it. Give me 1 second. So talking about Miss Harris's testimony.
What we must do is a very fact-specific analysis, and we must weigh Ms. Harris's right to not self-incriminate with Mr. Peterson's right under the Sixth Amendment to confront those witnesses. Because of this, we have to analyze this and take it step by step.
Okay, y'all can hear, right?
The first step is seeing
Yes.
if we have a testimonial statement.
Okay.
Can they hear out in the audience?
And this is according to Crawford v. Washington, 2004, 541 U.S. 36. These statements were further defined whether to be testimonial or non-testimonial by the High Court in Davis v. Indiana, which is found at 547 U.S. 813 in 2006. Statements are testimonial when the emergency no longer arises, when the statement is being given in response to a future prosecutorial event. So we know that Ms. Harris, when she gave her interview with the district attorney's office, was giving a testimonial statement. Therefore,
fair use,
the first prong is met.
Fair use.
But the second prong is not so easy to establish. We need to determine if Ms. Harris was available or unavailable, which is a little tricky in this case, which is why we need to walk through each step.
Yeah.
So Ms. Harris walked into court and said, I exercise my Fifth Amendment right. That made her unavailable. But when they granted her use immunity, she was thereby available again. Yet she still got on the stand and testified in a manner that was not consistent. She said, I don't remember. Or she said, I was dishonest in my interview with the district attorney's office.
Yeah.
Therefore, because of the way she was testifying, they decided at first to take this interview, which at the time we did not have a transcript for. And they were playing portions of the recorded statement to refresh her memory that the jury heard. So at first, that was going on in her direct. Then in her cross-examination, as she continued to testify in this varying manner that wasn't the way everyone expected her to testify, they entered the entire recording into evidence. But that recording was not entered into evidence while Ms. Harris was giving her testimony. It was entered into evidence on December 16th. And at that point, this is when the defense received that transcript, which we argue not receiving that transcript was a violation of Brady. And it also was a violation of Penal Code 1054.7, Your Honors. So we have this now statement in evidence, which is a transcript of a testimonial statement given to the prosecutors. In order to get this into evidence, they have first argued that they were going to use it to impeach Ms. Harris. This is because in their opening statements, the prosecutor said that Ms. Harris was going to testify that Mr. Peterson had violently pulled her by her hair from the car. This is a fact that was not proven at trial. Ms. Harris did not testify to this. Therefore, we feel that also is one of the inappropriate opening arguments. But additionally to that, we strongly objected to the late discovery of this transcript. And it wasn't just the late transcript. There were numerous other instances that the trial attorney did object to. But nonetheless, ultimately, the court did admit this statement under both Evidence Code 1235 and Substantive Evidence, Evidence Code 770. So now it's in, and we have a very unique situation here where we have a testimonial statement We have a witness that doesn't want to give us answers and is saying I was mistruthful in my interview only in September of 2022. And this trial was in December of 2022.
Yeah.
So it's clear that she did not want to cooperate. She said as much on the stand, I don't want to be here today. As a result, these matters, we feel that we need to look at the reliability and the prejudice to Mr. Peterson. And as Ms. Harris stated, I didn't tell the truth. So we can't rely on these statements from her own words. And this did greatly prejudice Mr. Peterson because in that interview, Ms. Harris said, my friend and I were attacked and it was this man's fault. And then at trial, she did not verify those statements, but the jury still heard those statements nonetheless. And we know that the jury relied on these statements because during deliberations, they did ask for a copy of that transcript to further analyze it. Therefore, we feel that the totality of this circumstance really does show that Mr. Peterson didn't have a chance to confront that witness.
Okay, real quick, Jag, before we move forward. Yeah, we got permission to use this audio, but very, very be conscientious. They say that we have to be fair and dignity since we're media. So let's not get too much with the feelings of the, this is, you know, just at the end we can do it, but not here, okay? You hear me?
I hear you.
All right, let's go.
Confessed that he did this crime. So the jury in opening statements at their first introduction to Mr. Peterson heard he's guilty and he said so, and I'm going to put a witness on the stand to prove it. But Mr. Edison never testified in the trial. Mr. Edison was not being cooperative with the prosecutors. In fact,
and Mr. Edison is the...
In November 28th, 2022, the court had to put a body attachment onto Mr. Edison. And on December 5th of 2022, Mr. Medesian, our trial attorney, actually filed a motion in limine specifically for this. And he stated that he was very concerned that Mr. Edison not coming to court would severely prejudice Mr. Peterson. And he urged the court to not allow such statements in opening. This motion was not granted. And so the court heard that Mr. Edison was going to testify. When Mr. Edison didn't show up due to media coverage and comments made in the trial, it was implied that Mr. Peterson was responsible for Mr. Edison not being in court with no proof of such contentions, which further prejudiced the jury. The body attachment continued at that point, and he still did not cooperate with the prosecution. We know in California, due to Hawk v. Superior Court, which is found at 42 Cal App 3D 108 in 1974, this is the controlling case that supports the contention that opening statements are confined to a reasonable good belief of what the prosecutor feels he will be able to show in the trial. Reasonable good faith, arguably, very respectfully, is not having a body attachment on a witness. The witness may or may not be trying to avoid the process. We don't know. He's just not there. And so that's all we can rely on. And ultimately, what happened is exactly what Mr. Medesian was afraid of in his motion in limine. And what Hawk warns about is that we must have this reasonable good belief in these opening statements to promise something, especially when it comes to a confession, because the jury is going to believe the prosecutor. They're going to rely on those words and have the prosecutor guide them and direct them to show why Mr. Peterson was guilty. So because of the great weight that the jury naturally gives the prosecution, we feel that these statements were inapposite to a good faith belief. Generally, a court would give a limiting instruction and attempt to cure such a situation. But in Mr. Peterson's court, no such instruction was given. There was no curative instruction for these opening arguments.
So let me ask a question here. So are you arguing that any time a witness is subject to a body attachment, that should be, that any reference to that witness should be off limits in opening statement?
I think that the prosecutor should be extra careful in such a situation because they're going into this knowing that that witness is not cooperative.
Right.
So I think that if they say that they hope to produce such a witness, that perhaps
is there any way we can pause for a second? Because technically, by the rules of fair use, we need to give a little
hesitation. And I think it's especially true in the case of the evidence that we're dealing with Mr. Peterson, that it was a confession.
And so what was the evidence or indication that the people did not have a reasonable good faith belief that they would be able to produce Mr. Edison at trial?
We actually have no proof of the district attorneys ever speaking to Mr. Edison. The defense was never provided of a copy of any interview that they conducted on this witness. We have no physical evidence. All we have is an email from the district attorney in this case that said, I didn't disclose this and I meant to disclose it, but we are going to call this witness who will say that Mr. Peterson confessed to him. So I honestly, despite my best investigations, we cannot find where this statement came from. We cannot ascertain the veracity of these statements. That's why I think it's inappropriate. I don't think it's always inappropriate. But in this case, with these particular facts, I do feel that it's inappropriate. And there was also problems in closing arguments, which contained inaccuracies. And it presented the evidence in a way that misconstrued the actual results. Here, I'm specifically talking about the DNA evidence. So we heard the prosecutor close the case by telling the jury, don't be fooled when we hear that Mr. Peterson is excluded.
We'll recap, Jennifer, for sure.
That's not exactly what the evidence said, which they had in their possession. I feel that statement really misled the jury. It may have confused them. It played on their emotions. And we know that that's not appropriate in closing statements. And in order to really understand the weight of that statement in closing, we need to understand what the evidence was that the district attorney had available to them. So as shown in our brief, in our reply brief, as for the magazine, there were 4 DNA profiles discovered on the magazine, none of which that were Mr. Peterson. Therefore, he was excluded from the magazine.
True.
As far as the firearm goes, they also found 4 different samples, one of which was a 90% male contributor. But Mr. Peterson was excluded from being that 90% contributor. Therefore, telling the jury, don't be fooled when you hear he's excluded is just not quite as the evidence showed. And
actually, it's telling the jury not to believe the evidence.
I want to clarify some key terms in science. So inconclusive, we heard in trial testimony, means it's not positive, it's not negative, it's just a neutral result. But it's not quite as simple as that. Actually, according to the scale of a likelihood ratio, which was in the discovery and presented at trial, likelihood ratios are the percentages. And we did not hear any percentages in Mr. Peterson's case, even though this evidence was available to the prosecution. This evidence was only given to defense upon our expert witness's request. So we did receive this evidence late. So this evidence was not presented in trial. It was presented in the motion for a new trial. But what we can see is that likelihood ratios that are 0, 0.01 and below are considered to be excluded. Likelihood ratios from 10,000 to 999,099 are very strong, very strong support to the prosecution that this person did leave DNA on this item. And then above 1 million is very strong.
Evidence tampering.
We found in the DNA evidence that they labeled Mr. Peterson's LR to be inconclusive and uninformative. And uninformative, according to this scale, is this an LR of 1. Therefore, Mr. Peterson had an LR of 1 in a million.
Wow.
That his DNA was on this firearm.
Wow.
And with that fact, it is actually marginally more likely that another member of the African-American population touched this gun over Mr. Peterson, which the jury did not hear. The jury heard the district attorney say, "Don't be fooled." But there's also no proof that Mr. Peterson did anything to fool anyone about this evidence. He presented his defense. It was their testing. We went off of what their testing said. So I just think that that is a very strong contention.
It's very interesting
in 1999,
because what it sounds like is that even though the prosecution had access to know that his DNA was not on it, they literally disagreed with their own evidence that they had, the evidence that they procured, that they collected, and told the jury, hey, don't believe it. Okay, don't be fooled. It doesn't matter what we found. Don't be fooled. And I just want to make sure that's what we're hearing right here, correct?
That's right.
Okay.
I'm going to get back on it.
Show reasonable doubt for them to find him not guilty. The jury just didn't hear that. They heard that Mr. Peterson hoped that they would be hoodwinked in the alleged closing arguments. So due to these statements and the misconstruing of the evidence, we feel that that was a very significant issue in the case. And finally, we feel that the Instagram post, as we discussed in our opening brief, this was a Brady violation. This post was given not only late, but it also was not redacted. It was riddled with hearsay. This post is significant as it also implies a confession, because what we have is actually various people posting, and this was in September of 2020, and they were posting that people were saying that, oh, well, if Mr. Peterson didn't do it, then Ms. Harris must have done it. And Mr. Peterson's social media manager commented on this post, no, they're not. And so that was used as an admission. But many celebrities don't run their own social media accounts. This is significant because, number one, had that discovery been given timely, we could have provided the statement that was provided in the motion for a new trial by Mr. Farias, stating that he is the one who runs Mr. Peterson's social media account. He made that post, and he didn't ask Mr. Peterson before he made that post. So that right there, we could have, if it was not late, presented a defense. But because we didn't have that, we were caught off guard. We were always in a position of reactive instead of actually being able to produce a good defense on this case. The Brady rule provides...
Let me just ask one question at one thing you said. Yes. Were there requests for redaction of that exhibit or of the post?
Fair
I
use.
believe there were, yes. Mr. Medesian did do a very good job objecting throughout the trial. We also must remember that Mr. Medesian only took over this case 2 weeks to a month prior the start of the trial, because the first trial attorney did withdraw and was permitted by court. Yet, I understand the court allowed that, but as an attorney, that's a very big feat to step in the shoes of another attorney so close to the trial. So I feel that all of these arguments we're discussing today, we do need to take that into consideration overall with them and think, in the alternative, this could be an effective assistance of counsel. But the Brady Rule provides that this exculpatory evidence must be provided to defense whether or not a request was made. The suppression of this evidence, it doesn't matter if it's willful or accidental, so long as it was suppressed. Then that is the problem right there. And I do have a 3-part test, which is found in the United States Supreme Court in Strickler v. Green, which is 527 U.S. 263 in 1999. They reiterated the 3 components of a Brady violation.
I'll be right back.
The evidence must be favorable to the defendant. Here, yes, the evidence was favorable. Had we gotten that Instagram post earlier, we could have brought that declaration in trial saying Mr. Peterson doesn't run his own social media accounts. Had we gotten the DNA evidence and not had to request that from the prosecution, we could have prepared for a better DNA argument, having the full picture. Had we had the testimony, the transcripts from Ms. Harris's interview,
I'm listening. I'll be right back.
We could have questioned her on cross about her interview. We also likely did not get fingerprint evidence on time. We did not get, and the fingerprint evidence actually showed that Mr. Peterson's fingerprints, were not found on that weapon. Currently, we are attempting at the Superior Court to have them run the serial number to identify the owner of the weapon, which was not done. And we are also attempting to retrieve either a recording or a transcript of one of the key witnesses' testimony. One of the key witnesses in the case, Mr. Sean Hawley, who gave testimony. We're attempting to get a copy of his 911 call.
Wait, you said Sean Hawley?
Sean Kelly.
Oh, okay. I'm sorry.
Sean Hawley.
Referring to
very
That's the attorney.
Yeah, no, very close. Yes, Sean Hawley was the attorney. Sean Kelly was the witness.
Okay, got it.
Different spellings also. So obviously we can see that this is favorable. The second question under that 3-part analysis with Strickler was it suppressed willfully or accidentally? Yes. This evidence was suppressed. All of these different pieces to where Mr. Medesian said, I feel like every day I wake up and I have an email from either the night before or the morning of saying, oh, we missed giving you this. And very respectfully, I say that. And the final component of this 3-prong test is, would it have changed the outcome of the trial? Yes. Absolutely. If our jury could have heard the full picture, the full accurate picture of just the evidence being laid out as it was, without these don't be fooled and, late discovery, I feel that it would have really tipped those scales to reasonable doubt to find that Mr. Peterson was innocent. And that's why today we humbly pray for exoneration of Mr. Daystar Peterson.
Yeah.
Thank you very much.
All right. Well, let's see how this plays out. I thought she said 30 minutes, but she didn't take 30. Let's see. So we have someone else stepping up right now. Jag, are you there? Apparently not.
Morning, Your Honors. May it please the court, Deputy Attorney General Michael Keller for the respondent. I want to begin by discussing the compelling nature of the evidence in this case. Within minutes of the shooting, the police found the gun that was used under appellant's seat. There were only 4 people in the car. Pete and Harris both identified appellant as a shooter. That first ID occurred within minutes of the shooting when Harris sent a text to a member of Pete's security team saying, "Help, Tory shot Meg, 911." Harris again ID'd appellant as a shooter in the recorded statement, and we can get to that in a moment. And Pete identified appellant as a shooter both before trial and at trial. Neither of them ever suggested that anyone other than appellant fired the shots.
Okay, they keep saying these words that will get struck from YouTube, but okay, let's go back.
Stating that he didn't even remember what they were arguing about, and he wanted to know the hospital where Pete was being treated. He blamed alcohol for the quote-unquote shit that he did.
All right.
That day, appellant sent a text to Pete, to the victim, and that text was preserved. In it, appellant said Pete would probably never talk to him again, that he was sorry, and he blamed again the alcohol for the quote-unquote shit that never should have happened. And then the third and final is the verified Instagram post that I'll also get to. Now, appellant's assertion is that he really wasn't accepting blame for having shot Pete, but for causing a rift in the relationship between Pete and Harris. And that's just nonsensical.
Why?
First of all, Harris told appellant she was at the hospital waiting for Pete. So if there had been a momentary rift that night, it was over because she's now at the hospital waiting for her friend that she's known for 7 years to be released and checking on her. Second, appellant didn't apologize to Harris, but yet he anticipated that Pete would never talk to him again. He was clearly accepting responsibility for something very big, something that applied to Pete, but not to Harris. And as appellant said he couldn't remember what they'd argued about, he wasn't accepting blame for anything he said. Finally, appellant said that he expected to receive backlash once word got out. Now, backlash for causing a rift makes no sense, but backlash for shooting someone does. The evidence in this case was compelling. Turning to a few of the issues that have been highlighted here today, I'll start first with the Instagram post. This was appellant's verified account. And a few times today I heard opposing counsel mention Brady, but Brady was never mentioned in appellant's opening brief or the reply brief. It can't be raised for the first time at oral argument. And frankly, it has no application here because the things that were turned over were inculpatory, not exculpatory. So when it comes to the Instagram posts, they were turned over upon realizing them, and there was no, many of the case, as you'll see in the respondent's brief, many of the claims that appellant raises are forfeited by a lack of objection at trial. And one of the things Your Honor asked is, did counsel ever ask for redaction? I don't see that anywhere in the record when it came to the Instagram posts. In fact, counsel didn't even object on the discovery basis. The objection was solely based on foundation. So discovery doesn't work for appellant on appeal. And as to foundation, the question really is whether or not there is an inference that can be drawn that a statement was made by a party. If so, it falls under the party opponent exception to the hearsay rule. And in this case, it's a verified account. And the fact that there may have been somebody else who had access to it to respond and may or may not have had permission, that would all go to weight, not to admissibility.
Okay.
Turning to the issue raised about the Harris recording.
Let me ask you a question about the Instagram post before you move away from that. And I guess the question is, if there were some sort of error in admitting that post, what would your argument be about as to whether that was prejudicial or not?
Yeah, it certainly wouldn't be prejudicial, Your Honor, because first of all, at trial, it came out about these other aspects. In other words, do we know for sure whether or not this was appellant personally authored or approved of it?
Right back. This
There's
guy
some
is
question about it. But what we do know is he did send the text. What we do know is he did make the recorded phone call. Like, that's his voice. So, and by the way, I would say that on the Instagram post, the post, all it said was, Harris didn't do the shooting. He didn't say, I did the shooting in that. So it's no more incriminating than the other admissions that came from his phone in a text or on in person in a voice recorded call.
Okay, well, this guy.
So turning to the tape recorded statements that were made by Harris to impeach her as prior inconsistent statements. When she was on the witness stand and made a number of inconsistent statements, the prosecution impeached her with those prior statements. Much of the recording, pieces of the recording came out during that period of time. While she was still on direct exam, the prosecutor announced a desire to play the entire recording at a subsequent time. And that was that's 5RT 3664 through 3665. Now, this puts the defense on notice that the entire recording is going to be played. The defense has an opportunity to object to it, to portions of it, and counsel doesn't do so. Counsel instead has an opportunity then to cross-examine on anything and everything that's in the recording because counsel knows that the entire recording is going to come in. So a confrontations clause claim just doesn't lie. And then I would add that on top of it, Harris wasn't excused as a witness. At the end of Harris's testimony, I see nothing that would preclude Harris from recall. So a confrontation clause is for when the defense doesn't have an opportunity to cross-examine a person on it. Harris testified, although Harris initially took the fifth, Harris was given immunity, subsequently testified. So the confrontation clause just does not work on appeal. And lastly, I'll turn to the allegations of prosecutorial misconduct. On that, again, these are forfeited claims. Objections weren't raised. Your Honor asked a question about how do we know on good faith, bad faith versus, there was a body attachment. You have a prosecutor that is, because the trial court did inquire into it, and the prosecutor said that the witness was under subpoena, and the prosecutor said they had a good faith. That's a judgment for the trial court. Now, I would note that the defense counsel wanted more information about it. That was the time to raise it and to try to develop more details right then and there before the ruling as to whether or not this witness was going to be available and whether the prosecutor actually had a good faith. And the defense's failure to do so precludes the claim from being raised on appeal. And one of the things I'll note that is in the reply brief as to these allegations of misconduct that weren't raised below, the reply says, well, an objection would have been futile because it would have run the risk of highlighting the issue for the jury. That's not what decisions involving futility involve. The futility exception applies only if the record shows that the objection would have been overruled or that nothing could have been done in a curative fashion, not just that it might highlight an issue for the jury and the attorney had a tactical reason for not doing so. Unless the court has any questions, I'm prepared to submit on the brief and ask this court to affirm the judgment.
We have none. Thank you very much.
Thank you.
No questions. All right. Okay. So, all
Any
right.
rebuttal?
Yes, briefly. Regarding the text to Mr. Edison, there was actually a motion in limine filed regarding that text. It was filed on December 12th, 2022 by Mr. Medesian. He stated that without Mr. Edison present in trial and without the foundation laid, that this text message shouldn't be admitted. That objection also was not granted by the court, but was on the record nonetheless. I've heard the people say that there was not compelling evidence, or there was compelling evidence, excuse me, to find Mr. Peterson guilty. But I argue that there was not enough evidence because we talked about the physical evidence in this case and the lack of physical evidence in this case. We discussed the variance in testimony, where even today, it's still not quite clear what happened on that night. And I also want to talk about the Instagram post. The fact that Mr. Peterson didn't say, well, you know, it wasn't Miss Harris and it was me, that really doesn't matter. There were only 4 people present the night in question. One was Mrs. Pete, one was Mr. Smith, who was the driver, leaving only Mr. Peterson or Miss Harris in possession of that weapon, doing the acts that we're here for today. Therefore, it doesn't matter if he didn't confess. It was an implied confession because there was no question as to whether Mr. Smith or Miss Pete ever did these actions. I would like to remind everyone that Brady is willful or accidental. Brady says that regardless, the defense has a right to the evidence that's being produced against them in court. The incidents were very significant. The pieces that we were not given would have changed the outcome in this trial. For example, with the Harris recording, there also was an objection there for the Harris recording. That goes back to our motion in limine on December 5th. And in that, when there also was a sidebar as this was going on and these statements were being played to first refresh Ms. Harris's memory, you know, Mr. Medesian did object and there was a sidebar and the judge actually commented that it's just easier this way. And Mr. Medesian said, but procedure. And the judge said, no, it's fine. We're going to do it this way today. So those objections were raised in the courts. Those weren't waived. And honestly, as far as recalling Ms. Harris, there was no body attachment. She stated, I don't want to be here. I don't want to do this. She stated, I have not been truthful. And I can't speak for Mr. Medesian. So there is no record of why or why not she was not recalled. But I feel that the people did just make a good point that it was futile. I feel that at this point, Mr. Medesian, very respectfully, did feel defeated. He did feel overwhelmed. He stated in his objection, I wake up every day and have an email from late last night or this morning with another piece of evidence that the people forgot to give us. And I do feel that he lost some of his steam there, so to speak. And then because of that, you know, that's why I reminded the court that he had that very short time to prepare, and any objections that were missed should be construed as ineffective assistance of counsel. And in that, I submit.
All right. Thank you both very much. The matter stands submitted.
All right. Well, I'm looking on the YouTube streets and everybody and their mama.
We're in recess until 1 p.m.
Oh, dang. I knew it.
Thank you.
All right. They're in recess until 1 p.m. Yeah. So, well, I know you were muted. I messaged you, Jag. Obviously, you're not seeing my messages. I was just asking you, were you listening? Because I know you were muted. Okay. Okay. Yeah. Because I know you said you chimed in when you said the situation about the guy, he was pissing you off. What was pissing you off?
Well, I've been in court so many times. I'm very clear on when a lawyer is trying to cover their butt. And I'm very clear on when they're trying to push through certain narratives to make up for, you know, what someone else did. Because essentially, this wasn't his case. Whoever this is that's talking, he wasn't a part of this team. Right now, what he's doing is he's trying to justify what they did.
Yeah. Yep.
And it's sad because, you know, you can hear it in his voice. You know what I mean? You can hear it in his voice, and he's, well, Your Honor, can you just please just hold this up, because you know, the social media, like it's giving, please, and why me? Why did I draw the short straw today to have to do this case? Yeah, I don't envy him at all. What do you think?
Oh, no. Yeah, I mean, he's full of crap, and I think the I forgot the person's name, but the lady who initially came up and said, you know, what she had to say, she was on point, and she did a solid job at clearing, basically focusing on the trial errors that occurred, the mishandling, the missteps, the evidentiary mishandlings. She did a great job at it. I guess if they're coming back, you know, well, it will be in about 2 hours and a half. That's when they'll come back. I guess what we could do is maybe later we could maybe talk about, I don't know, are they going to come to a conclusion today?
Not sure. I mean, the truth is they might go back, they might listen, they might ask. You know, they didn't ask for any questions right now. They let everyone, you know, give their facts, give their details, explain their motions. You know, this guy is explaining why things should be held. They're explaining why, hey, this should be tossed out. This is kind of unlawful. This isn't fair. They're probably going to go back and listen. I don't know if they're going to come up with a decision today. They could, or they might come back and ask more questions.
Okay, so it looks like you got to ask the right questions. If after the oral arguments, the I think, well, they said they're in recess. I believe once oral arguments are completed, the case is considered submitted. As you heard, the appellate judges said submitted.
Right.
Typically, the court reviews the briefs, the trial record, and the proceedings on proceedings to deliberate on the appeal. So they have 90 days from the date of submission to issue a written decision or opinion. And it looks like they may affirm the lower court's judgment. They may reverse it in whole. They may modify it. They may remand the case or dismissal of appeal. The written opinion in the detail of the court's reasoning and how they arrived at their conclusion is decision is issued to the court, and the clerk notifies all parties. So they either send written opinion or order, I guess. So usually if they lose, they could file another petition, you know, within 15 days. But it looks like I said, I honestly think they did a great job at letting the court know, like, look, the there's a lot of missteps, a lot of mishandlings. This just them bringing up the fact that the whole thing with Kelsey, and then yeah, I mean,
and the social media thing. I was thinking about that as well. The simple fact that there was someone else that was controlling his social media,
right?
And they were using those posts as if it were him posting it and he wasn't even aware of what was being posted.
Yeah.
It kind of reminds me of something else that we're going through right now. You know, there's a contempt order against Tory because Tasha K, you know,
Tasha K made her a collaborator.
Exactly.
And it was a oops. Oh, I didn't know. Bull-ish. But that's a whole nother case. But it's the same ish, different toilet.
Kind of tactics, yeah.
Yeah. And there was Mel Tucker in the chat. She said something about the streams or something. Everything is fine on our end.
But when I went and I checked on the, you know, on my devices, it seemed to be working okay, but can't speak for everyone else. The only thing that I can say is shut down, refresh, come back. We all know the kind of games that these people play over here on YouTube.
What they're doing now is suppressing, especially stories like this, because of who it's attached to. There's an attachment to Rock Nation, and Rock Nation doesn't want any bad pub right now. It's bad already. I think they're saying, and I think Miss Lowdown said that they are replacing Jay-Z with Taylor Swift with the halftime show for next year. So that might be interesting. I honestly think the whole NFL thing, they can't be protected anymore. But that's a whole nother conversation. I just think any press that's involving this organization, the Lie Nation, Rock, whatever you call them, it's gonna get suppressed. And we'll talk more about this before last week, and you know, rest in peace again to my OG Dr. Funkenstein. Before I got the word that he had passed, I was working on a story about the collusion that TMZ does. I think people need to open their eyes and really see what it is that they do. And a lot more is going to come out about TMZ, but they are not the benevolent, they're just as dirty. I'll just say allegedly, because I know how that the legal team gets. But I know for a fact, because for my situation, when I tried to reach out about the crap that they put out there on Miss Jaguar, right? They just hung up on us. At first they wanted to talk, and then they hung up. But yeah, there's a lot that goes on behind the scenes, and these people are it's all CYA right now. Kind of takes me back to what you said about that attorney, that man, the male attorney. He was on a CYA mission. He was covering his A.
But see, this is the thing. And Jay, just to give you a better idea, when the motions came to put the gag order on Demore, they had already started preparing their contempt orders of what they were going to ask to be considered her being in contempt of the order. Basically, just their way to try to stop, the real information from getting out, because it looked extremely damaging. It looked extremely damning. Tasha K was one of the last people to interview Demore before the gag order was set in place. And we were one of the first. So what happened is after the gag order was submitted and set, from that point forward, Demore wasn't allowed to do any more social media posting. It had to go before the judge, and the judge would give instructions on what could stay, what could be taken down, what she could say, what she couldn't say. Tasha K then decided to put up a post promoting the interview, and she
made her a collaborator.
Demore a collaborator.
Why would you do something like that unless you're working with the ops, allegedly?
Well, I mean, the reason why you do something like that is to get someone to make it see, this is the thing. When you list someone as a collaborator, it instantly, they have to accept on the other end. But even still, it lists their account. So it makes it seem like she was going to post anyway.
And then
accept.
Well, no, she wouldn't. I don't think she wouldn't accept it. That you know, I don't think. Yeah, I think they know a little bit more, especially what's going on now. But
They've been forced to learn.
right. You know, just it's kind of like, yeah, it's a hard learn. But one of the producers did it. Oh, it was a mistake. I hear that a lot. Oh, that was a mistake. It was an oversight. No, you do not like. Bro, I produce for you, Jag, and I look. Even with producing the Damari Hadley story, Defending Your Freedom, when the kids are in the, you know, the pictures and in the video, as a responsible producer, what did I say?
Blurt it out.
And that's what happened. That's what we did. So
to protect the faces of the children, so that no one would be able to, you know, dox them.
Yeah,
like that's what you do. That's what you do. A responsible job. But what I find interesting is that seems to be Trasha K's new objective for everything, ever since, you know, the Cardi B lawsuit, and she lost. Now what she does is she blames everything on her team.
Yeah.
She can say, oh, it wasn't me, my team did it. Oh, it wasn't me, my team did it. Oh no, I didn't do that, my team did it. Like even in the interview that she did with Damari, when she said, oh, well, my team did a bunch of research, and, you know, they think you're just paranoid. They think you're just paranoid. So she doesn't have to be the one to say it.
Right.
And it's kind of like the same thing that's going on, what we're hearing about in this Tory Lanez case. There was social media things that were addressed that he had nothing to do with. And even the way he was talking about, oh, well, you know, he was more worried about creating a rift between the women, and it makes more sense that what he was really worried about was the pow-powing and yada yada yada, and so on and so forth. And I'm like, what he said didn't even make any sense. Talking about, oh, well, you know, I don't think that he would be worried about covering stuff up because of, you know, a rift between two women. Understand this. As a public figure, you have to be concerned about all things that are negative press on you. All things.
Yeah.
All things.
Yeah.
There are some people who get drugged through the mud, through all of the blogs and all of the tabloid and all of this and all of that over nothing all the time. So just listening to him try to minimize what would be said, what the backlash would be. And let's be clear about this. It wasn't just between the two women. There was also Kylie Jenner involved in that whole situation as well. They made it seem like Tory was going out of his way to create odds between all of these women, you know, as the object of their affection, whatever the case may be. Yeah, there's plenty of people who do social media cleanup to, you know, explain certain things that don't look so good in their personal life. But to say, oh no, it makes more sense that what he would be worried about was the pow-powing, then no, it doesn't make more sense. You're trying to make this seem like what the prosecution did made sense, and it didn't. It didn't. Not at all. Not in my opinion. I don't know.
No, it didn't. You cannot. That person cannot really sit back and, you know, really justify or make some type of logical justification for what it is that they did.
The simple fact that Kelsey admitted that she wasn't telling the truth.
Right.
The simple that the attorney who got switched in at the last moment, and let's just be honest, with a case like this, when you're going up against the state has all the help in the world that they need. They've got all of the people writing the briefs, doing the research, checking to this. They got all kinds of paralegal help. They got everything going on. To have to fight against a machine like the state, and you're a new lawyer coming in, and the state is literally giving you, you know, oh yeah, we forgot to give you this. Oh, we forgot to give you that. Oh, this. The night before. He had no time to prep. He was coming in the odd man out that late in a trial where that much information had been disseminated. Like they did everything that they possibly could do to handicap a fair defense. And the truth is, Tory's lawyer had no choice but to give him ineffective counsel based off of the constraints of time and not being allowed to properly catch up. And more importantly than that, whoever he took over for kind of screwed him, because it doesn't sound like they gave him enough help to say, okay, all right, this is a big case. So here, boom, boom, boom. Hey, let me give you one of my paralegals to help keep you up to date, because this is how this is going. Like it was just throw you out into the middle of the deep end of the ocean without a life raft or without a life jacket and say, yeah, I hope you make it to shore.
Yeah. Good luck. Like they hopped on the plane or they hopped on the boat and it's like, well, good luck to you. Yeah, man. I'm glad you got eyes and ears better than me, because just like I say, sometimes I just be bypassing certain information, but I didn't bypass it. It kind of just was like, oh yeah, she did admit that she lied, and yeah, and again, I'm also, remember, we're all it is just a commentary, so
yeah,
that's all it is. That we're not trying to dissuade the opinion or anything. Just look at it. Everyone really just needs to look at it. Ultimately,
well, that's the thing.
See it for what it is.
You can look at it, but the truth is there's people that are going to look at it and they're going to see what they want to see. There have been people that have their minds made up about wanting Daystar Peterson to be guilty from day one.
Yeah.
From day one. And, when his verdict came in, I told everybody, you're not going to be happy with the outcome, and it is not going to be what you think. And I could have said something, because I was like, they're going to find him guilty no matter what, because of what I heard. I heard that the fix was in. And I heard that the fix was in from someone who worked at that courthouse.
Wow.
So, yeah. And I heard that very, very, very early on in the trial. Allegedly, the fix was in. And, here we are now. And we're not trying to solve this case. We're not sitting here pretending to be lawyers or attorneys. We're not sitting here saying that our opinions matter more than whatever the outcome is going to be. What we're saying is that the reason why things like this happen is because people aren't watching, because people aren't paying attention, because people aren't informed with the right information, or at least the accurate information.
Yeah.
So I guess we're coming back. Huh?
Yeah, we shall reconvene later. Let's do it. I guess we'll just do the regular live. We'll do it that way. You know how we normally do. Because I still got to get into this StreamYard BS, and we about to make some major changes though, Jag. It's about to be real nice. In fact, speaking of, let me get on the phone, because we gotta talk to some folks about some things, because yeah, I know y'all like, and I appreciate everybody who comes to these channels and they check out Jag every day, because she's pretty much online every day.
Oh, I'm not.
But well, yeah. Yeah, in general. But everybody, and I'm sure y'all could agree to y'all want to hear music. Y'all want to do y'all want to hear her music? Y'all want to hear new music? Do y'all want her to get back to that? Because I think she, she showed y'all mastery. We were live in certain people's studios, and she was just, y'all seen it. She that this mastery. So I'm making a concerted effort to really just make that a thing, get that music back out there. There's content creators who are online, and they must have heard you yesterday, because you was going in talking about you not a one-trick pony, and you're not. You are an investigative journalist. You are a singer. You are a you got it popping right now. Now someone wants to say, "Oh well, yeah, I got songs too, and I do this, and I got like, goofy
No, you
ass
don't.
out of here." No, yeah, you do AI, and that's you. Look, let me say this: if
I'm
you
gonna be
do
very
any AI, if you do any AI music, even with like production, I'm starting to look at they have a co-producer AI help, but I still produce my own music. I'm not using AI. Make me a beat, AI. I'm not. No. If you touch AI and you type in lyrics and no, you're not an artist. You're not an artist.
Let's be very clear on something, and I'm going to say that as someone who is a master at my craft. Now, understand this. 10,000 hours at doing any one thing gives you mastery status. That's a fact. 50,000 hours at doing any one thing gives you grand mastery status. I've hit both of those things in all aspects of my career for what I am and for what I do. Now, we have AI, and don't get me wrong, I think it's wonderful that your average person just gets to be a creative and gets to use this app and gets to use these tools to be creative. But the thing is this: if you can't do it without it, there is no mastery.
Oh, Auntie
There's no
Leah. No, that ain't a shot at Auntie Leah. Hold on, let me clear it up, because Auntie Leah does great work with the sonography, but Auntie Leah doesn't run around here saying that she's this artist and she does blah blah blah. No, Auntie Leah does what she does, so that's not a shot at her, everybody, because the sonographies are on point. You know what I'm saying? That's
and like I said, it's wonderful that we have these tools. It's wonderful that we have these tools for people to become creative and to express themselves creativity. That's
right.
What AI is a function of, helping your average layperson express themselves creatively. But let's be very clear. There's a lot of people that want to take this construct and say, oh yeah, I'm just as good as everyone else who is a master at this because I did this, because I did that. And I just want to get it clear and explain it, the difference.
Yeah. No. And that's why I was saying too, AI can help me. I'm going to use it as a co-producer, but I still write my own stuff.
Yeah, absolutely. But let me land on this.
Go ahead. Sorry.
Okay. So if I sit down at a blank canvas and I take the pen or the sketch pen, or I just go freehand with oil or acrylic or whatever the case may be, and I create image, vision from my mind, from myself, that makes me an artist.
Yeah.
Now, if somebody can take that canvas and put it through a digital processing machine, and then recreate the sketch and say, here, you too can paint this painting by numbers. And they take all of it. You know what I mean? Now don't get me wrong. You painted it by numbers. You followed this number for this color and this number for that color. And they had it all sketched out, and you stayed within the line, even though it might almost look identical to the original. That's not art. What it is appreciation. What it is a hobby. What it is inspiration.
Yeah.
But it's not the same as the person who was able to create that out of thin air from what God blessed them and divined them in their mind. And I think that's the thing that, bothers me most when it comes to a lot of this AI work. for people who are looking to become something, or to become famous or successful for something, the fastest way possible. AI is a terrible thing. It is, because it gives them, this false sense of, hey, look at me. I can do this and I can do that and I can do this and I can do that. But if you can't do it yourself, let's not forget what AI means. Artificial.
Yeah. Now,
yeah. So it's and salute to everyone who is getting creative and painting by numbers, because that's how I see AI art. I see it as no different by numbers.
Yeah. No, and you're right. And look, I was gonna shout out Auntie Leah and her channel. Y'all go kicking it with Auntie Leah. See, the thing is, Auntie Leah is creating using AI, because even the sonographies that she did, like she did the sonography for, what was it, James? What was his name? The guy? I'm sorry, Jamal Roberts, right?
Jamal Roberts, yeah.
You have to research. You got to find out more about this person. You're not just putting, because AI probably don't even know who Jamal Roberts is. You have to create the story, write the story, and do so. Being creative like that with AI is straight up on point. But if you're not using your own voice, you're not using your own instrumentation, if you do, and you run around thinking you a singer, like, oh yeah, I'm a singer, you're not. You're looking crazy. You're not. Yeah, and that's one thing. Yeah, AI does not create. AI it just replicates. So
that's it.
Even when a singer is, I'm an AI singer, all you're doing is typing the words, and you're trash. Stop. But big up to the people who take AI and create whole new, like I said, the sonography is hella dope. Like, I'm gonna look into it and be like, yo, do a sonography for Dr. Funkenstein, rest in peace. Do a sonography for General Jeff, my guy. Like, I think that's dope. That's a dope concept, and you use AI to produce it. It's dope.
But let's not be clear. Or should I say, let's be clear. There are a lot of people on this app that are running around calling themselves, oh yeah, I'm an AI artist. I'm an AI artist. Think about what AI means. Artificial intelligence. I'm an artificial intelligence artist. Like, y'all need to really think about that. Oh yeah, I'm an AI artist. I'm an AI this. I'm an AI that. Artificial.
Crazy.
I don't want to be an artificial anything.
You want to be all original.
I want to be real.
All original, not art official. Yeah, that's why I give you your props, Jag, because even just, your God-given talent, that's why I'm saying get back and give this to the world, because this artificial bullish that's out, people think it's just acceptable. They just think that's just what it is. It's like, nah, you got to show real mastery. We need to start showing real mastery. So your grandmaster, you said 50,000 hours you done put in plus. Yeah, of course. And it shows. You need to show the world again what it really do. So big ups to you for that, because AI can't beat you. You remember that? What was that? John Henry. The John Henry can cut through the mountain versus the machine. It was like, John Henry's like, I'm gonna beat it. And I think he did end up beating it, but how the story don't go, he fell out, and he was DOA at the end, but he fought against the machine so hard. That's like a representation of Jag, but she's not gonna be DOA at the end. She's gonna be victorious. No. You know what I'm saying? So your artistry and what you do, you hit the mic and you ain't got it. It ain't typed up. Somebody said, well, no, you hit the mic, and you don't even we don't even use Melodyne for the most part for you. And Melodyne is like a mild form of auto-tune. And it's just a pitch correctness. That's basically what it is. Jag don't even need that. So
You want
I'm
to know
not
how
right. I'm
I'm going?
not glazing. I'm not glazing. I'm just saying the reality of how amazing. So
You've recorded me yourself, but the thing that really broke my heart was, in the past 10 years, I've gone into the studio with numerous different engineers, and to look at how surprised they were.
mhm.
I don't have to use auto-tune on you. The notes are all right, and
Yep.
whoop-de-woo. And
Yep.
it's scary to me. It's scary to me because I remember being a kid and going into the studio, and that was a requirement. You being on pitch, on key, you being in right timing, in right step, you being able to come in on your mark. Now it doesn't even matter. You can put an artist in front of a microphone and they can sit there and say a whole bunch of crap. And guess what? They can go back and they can fix your pitch to make it sound like it's supposed to sound, which means you
Listen to your flow.
They and they can put you on cue, right? Because you didn't come in at the right time. And it's wild, because I'm thinking about the whole Cardi B thing. Oh, and by the way, anybody who's looking for any other lives, they're all on members only status. And that Cardi B video is in the top membership.
It pissing people off. I know it pisses people off.
Good. That was the point. The point.
And you did an excellent job.
People wonder why. No, because we need to piss people off. We need to get people upset. People need to be enraged. And people need to start giving answers. People want to know why this person has never been on tour. She's supposed to be this big star. She's supposed to be this big artist. She's supposed to be all of this stuff. She's never been on tour because she probably doesn't know how to make it through a whole show.
Shout out to Tawana in the building, Tawana Houston. Before you get on with what you're gonna say about Cardi, I said let me run this back because with your singing. And like I said, the mastery that I witnessed, and I'm honest. I'm be honest. I'm not used to working with R&B singers, neo soul singers. Pretty much, it's rap. So I've always been on some like bars. Number one, flow. Number two, delivery. With the MC side of the game, right? Enthusiasm. Conveying your feeling, however it is that you want to sound on the mic with the rap shit. So. I did this skit. Hold on one second. Let me play real quick because I did this a long time ago. I did this a while back. So I know you're very familiar with auto tune, and I created something called auto flow.
Rappers, listen to your flow. Now listen to mine. Now back to yours. Now back to mine. Sadly, yours isn't tight. But if you stop fucking around and get with this new plugin, you might be able to get your shit right. Auto flow. Go from sounding like this.
Illuminati, worship the Nazis.
Oh my God.
They want 90s with MLK.
Come on, stay on beat, stay on beat.
With AKs, not minors. Brainwashed soldiers.
Fuck that. Turn it off. Turn it off. All right. Oh my God. To sounding more professional with a more professional flow like this. Set it to the highest settings. Detroit White Boy 313.
Liberace's, Versace's, and you Nazis. Watch me, cause you thinking you got me in this hot seat. You motherfuckers wanna judge me, cause you're not me. You never stop me, I'm top speed and you pop me.
Oh yeah, that's what the fuck I'm talking about. That nigga was bitten.
Okay. Yeah, I was gonna get into the app development and create that, but
a mess. No, but seriously, it's I don't think people really understand how offensive it is when you're forced to sit around and watch people be called artists when you know that they're not, when they know that they're not. But it's funny because with enough money and enough influence, people will accept or just allow people to be given a certain status that they really haven't earned and don't deserve.
Yeah. So that's why you got in on Cardi B.
Oh, well, absolutely. And not just that, because of all of the, oh yeah, and the Jigga Man gave me, and yeah, and the GOAT, he gave me this and he gave me that. He didn't give you anything. Angela and Renee made that possible for you. And I really get sick and tired of listening to people not know their history, not know the work, totally disregard the genius and the legends that were here before. That song has been around for 44 years. It was around for 44 years. It was integral. It was there for you to crap all over and destroy. Like it's not gone. It's just on members only.
No,
the live members, huh?
I say yeah. No, it's not. Go ahead.
Yeah. So it's just not available to the public. And you know, the truth is, the members asked. We gave them a choice, and we asked if we should make the Candace Owens Live members only. And guess what? They said yes. So yeah, members get first dibs. They do. And if you guys want to see it, I don't know, because I'm just saying, with the mobile uploads, are we able to cut things up like we used to be able to?
Yeah, we can.
Here in the studio,
just let me know. Yeah, just let me know.
I was going to say, what we can do is we can just go in and edit, because the Candace Owens, because we were live for like an hour and a half, just listening to music and having fun with music. And that right there, that moment is for the members. But the commentary on Candace and all of that, maybe we can go and we can just cut that piece, and then we can make that public.
Let's do that. And then let's unpack it even more on the Jaguar Right Uncensored podcast. Because I think people want to, like, I got some questions for you.
Okay.
So the Jaguar Right podcast, yo, let's really unpack it. Uncensored. Jaguar Right Uncensored.
Okay.
That's what
sounds good.
Okay. But I didn't know if you want to rap, or because I got to get on the call. Yep. I got to get on the call.
All right. Well, then, guys, we'll see you later when they come back to court. And
well, I guess after they come back to well, if you want to go live, like you said, we'll do it that way, because then I could play it. We'll figure it out, because I'm not going to set up another stream like this. We'll just do it how we normally do.
Yeah. Let's tap right into the main vein.
Let's do it.
All right. See you guys later.
All right, y'all. Hold on, y'all. I was trying to find something to go out with. I guess that's it. I don't know. All right, y'all.
Why was Mo and O clipped that day? I don't know. Why did they blame Yellow Beezy? I don't know. Truth is, Boosie had a lot to gain by watching Mo 3 move around. Maybe that's why they shot him over there at the Big T after the wake. A lot of shit goes down at the Big T, but for Boosie to get shot, I guess that's why Mo 3 got shot right over there. I guess that's why I couldn't stay in Dallas. I had to get out to watch Mo 3 be assassinated, executed, running for his life down this highway in the middle of the day. Like, it was this time of the day. Look how busy this is. And somehow he was forced to stop his car. Someone stopped their car as well, got out the car. He saw them, he must have recognized, because he turned and started running down the highway in the middle of the day. And they shot him in the back. This make any more sense than the Tupac shit? How the hell was there enough time on a busy highway like this at this time of the day? Who does a shooting in the middle of a highway? She in the middle of the day. And still no answer. It's always too hard to solve a rap murder. Another graveyard.